There we go. Okay, I think we're good. Okay. Did somebody else join? Nope. Okay. Thanks everybody. Lunchtime, day before Thanksgiving. I guess that so I'm glad that we've got the people here that we do for today. I was looking through our notes from the last session, and I do want to, what? You'll need to go back to the window you're shit. Hold on, I can't swap windows when I'm sharing. Do you guys not see, hold on, do you guys not see what I'm sharing?
I see it.
Okay. That's weird. Teams just gave me a note saying that it's not doing that right now. But whatever, if you guys can see it, we're good. So I went back through our notes. I think we've got a good start on the outline for civil commitments, and EDP in addition to that. What I'm hoping we can do is flesh out a rough idea of the remainder of the case types, if possible. Although I also want to double check Jordan, because if I'm not mistaken, the criminal work group is also covering contempt, like civil or contempt.
We did discuss contempt stuff. It's currently lumped in with the misdemeanor qualifications, and unless this group thinks it needs to be somewhere else, that's probably where it's going to stay.
How does everybody feel about that? I don't have a strong feeling one way or another. I've done contempts, but not a huge number of them. So
my only thought really is that contempt and material witness representation, there may be some overlap, but we may be able to group some of those together. That would be the only reason I would think of, why we might want to keep it with the other quasi-criminal. I'm just thinking about what you need to qualify for material witness representation. Some others we may have, these can be subgroups that would be grouped together, but that would be the only thing I can think of.
So here's my, I guess, my question on this to pose to the group. And I don't remember if I talked about this last time or last week or not. Frankie, my wife, handled back when we were down in Roseburg a civil punitive contempt. I know there was a little bit of chatter on the pond about it over the last week as well. And there's a lot of tools in civil practice that aren't usually, my question is, how usable are those across the variety of contempt? So if you've got a contempt VRO, for those who know contempt and the civil world more, are you able to do you have access to the procedures that you would under, or is it more limited to criminal? Because that may be the, like, you have a right to appointed counsel on a civil punitive contempt if, at the very least, any jail time is being asked for as a sanction. So I'm going to toss that to everybody here to see if we've got a good answer for that.
I think that's a
And I guess you raise a good question about where contempt should fall in this, and I think some of it is going to depend on when you're allowed to have court appointed counsel. I don't know every situation that would be, from the starting point of every time you'd have a right to court appointed counsel in a contempt, taking that into consideration, I'd have to follow up and see, okay, what procedural rules are going to apply.
Okay. Anybody else have anything additional? It may be that we want to kick this question to next group, so there's a little bit more research that folk can do before we answer it. Let's do that then. Ed, are you volunteering for that, I guess?
Yeah, and just so where would be the best place for me to sort of focus on when there's a right to court-appointed counsel for contempt?
That's a good question. If
Okay.
I'm remembering right, there was a statute. I'll take a look back at the pond thread because I think somebody mentioned a statute that specifically delineated what procedural stuff, what criminal protections get ported over to civil contempt procedures. So I will double check that and send that your way, and that might be the best place to start.
Okay, and I'll look at the court-appointed statutes. I've
Yeah.
not been the best at finding the Defense Commission's regulations and policies, how they approach those, but I certainly will look at the court-appointed statutes and see if that it tells me anything about contempts. And yeah, but I'm happy to try and determine what procedural rules would apply in any situation where you'd have a court-appointed counsel for contempt. Thanks.
Cool. Okay. You brought up material witness warrants as well. Is there, thinking about this from a standpoint of qualifications, is there a substantial difference in representation of a material witness, a aside that would be different substantially from representing, or that would need to be greater than your representation of a criminal client?
My sense is if you know privilege well, and especially Fifth Amendment, if you know privilege well and, evidence and privilege, I mean, I think that's really what you need to be qualified. I mean, I was thinking about that the last time, but really the issues are, privilege that you should know as criminal defense practitioner.
So do we need to break this out then? If we could say material witness representation is handled under the criminal qualification standards, would that be sufficient? Do we need something separate?
I
As
can't.
in another work group should be working on it, and they just classify at what level of that. That kind of makes sense to me. It occurs to me, for whatever it's worth, that that the person should be at least felony and probably major felony qualified to represent. I mean, it seems like the material witness, you should probably be qualified to handle whatever kind of case the material witness is being called in. Makes sense to me. But I think it's okay to punt it to criminal, get it out of quasi-criminal.
That makes a lot of sense to me as well. Ed, what was you I know you were going to say something too.
Yeah, I just, I can't think beyond privilege. I think if we were addressing it, we might want to look beyond not just what kind of case the witness is being called in, but you're going to want who's ever representing the material witness to be able to cover anything that the witness potentially is asked about and covered. So it could be, exceeded. It could be a misdemeanor domestic violence. The witness is called in and they end up getting asked questions that open the door to much more serious implications for them.
Right.
So that's a thought. But I think, I don't see a reason why criminal work group shouldn't be able to handle that.
I mean, my immediate thought along those lines is that any material witness risks perjury. So even if they're being held on a misdemeanor, even if they're being called on a misdemeanor, you have the issue of, well, perjury is a felony, so probably somebody has to at least be felony qualified on that front. But Jordan, is that something that?
I mean, if this group wants to move it over, we probably will not have time for a very in-depth discussion of it. We've got 1, maybe 2 meetings left to figure out the rest of what we're going to do with Measure 11 and sex felonies and then murder. So I don't know that we're going to have a lot of time to devote to that.
Can we make a would it work if we were to say make a recommendation of how this might fold in?
Yeah.
Okay.
I suspect if we make a recommendation, it will get adopted.
Fair
without
enough.
a ton of discussion. So it may be better if this group thinks there are particular standards needed for material witness representation beyond like eligible to represent people in felony cases, then we should discuss it. If we think that, having the ability to represent people in felonies is going to give you the ability to represent most material witnesses, then I think we can just say that.
So for this group, couple of things. Number one, Jordan, please correct me if I'm wrong, but the hierarchy that the criminal work group is looking at is misdemeanors as the low-level category, all felonies as a second category, with the exception of murder, Measure 11, and felony sex offenses. Measure 11 and felony sex offenses as a third tier, and then murder as a fourth tier. Is that right?
Yep.
Okay, so if we were going to mesh that
I guess,
in,
and gun minimum cases are probably going to get lumped in with that third tier.
okay,
But
interesting, cool. Oh, so just like things that have minimum sentencing.
No, more like things that have minimum sentencing that are not dependent on someone's prior criminal history.
Gotcha. Okay. Joe, you got your hand up.
Yeah, this is just back to, I know I reviewed the statute. It was my instinct that they can't actually issue a material witness warrant in a misdemeanor case. And I think that's the intent of the statute, although there's an argument that somebody could be called. But I think the intent of the legislature was not to allow material witnesses in misdemeanor cases.
I wish I had known that when a witness who testified in the first trial that led to a mistrial failed to show up for the second trial, and the judge told me, you either ask me for a material witness warrant or you're going to have to go forward without this witness. I'm not letting the transcript from the previous trial come in. It was like, yeah, so great, cool. Thanks, Judge. You gave me a completely non-legal option.
Right.
Sorry.
Go ahead.
I had assumed that material witness representation would also cover in this scenario where a witness invokes, witness is on the stand and invokes, and then they have right to representation. So I may have misunderstood, but I was thinking our qualification would also cover that situation.
I would imagine so. I don't know that the situations are different enough. I mean, for the same reason that there's a ton of different circumstances that come up in any other type of case, I think one qualification standard to cover any type of material witness representation, or figuring out how to manage material witness representation in another in the scheme of a different system, would cover any kind of material witness issues.
Sure. The major difference between a witness that invokes and a person subject to a material witness order from a judge is the person subject to the material witness order of the judge is subject to restrictions on liberty, including being jailed pending the trial. And so I would say certainly knowledgeable of the Chapter 135, specifically the release code, would be something that would be important for material witness stuff, primary and secondary release criteria, and so on.
So let's approach this from the frame of, we're going to make a recommendation to the criminal work group of how to fit material witness representation into their scheme. What do we think? I mean, it sounds like the floor would be felony level representation. Like the attorney has to be at least felony level. Do we want to go with something like whatever? The issue, part of the issue being that there is little likelihood that a person appointed to represent a material witness would know before accepting that appointment what the exposure of that material witness is, right? You're going to get asked, And then you have the conversation with the material witness, and they talk about things that lead to, oh crap, we've got a hell of a lot more exposure here than I'm qualified to handle. We can mitigate that.
Well,
I'm not sure that material witnesses are actually subject to a lot of exposure. They're subject to the issues that somebody that is appointed to represent material witnesses, as my understanding is, whether they are material, whether they possess facts that are actually material to the case, and if so, whether they will show up to the trial. I guess that
beyond that,
I
mean,
contempt
if you end up
for not complying with this, I guess it risks a contempt for not complying with a subpoena or something. I've got an incoming call about a trial. I got a ticket. Apologize.
Okay. No worries, Joe.
I was just going to say the other thing that you'd want people in material witness representation to know is if the witness says like, yeah, they're going to ask me about this kid that I may have done some bad things with. What do I do about that? And I think by the time you've gotten enough representation under your belt to get to the kind of standard felony level that we're talking about, you really ought to know the answer to that is, oh, you shut the F up and invoke your Fifth Amendment rights. I don't think you need them to be able to handle like the full underlying child sex case that might come out of that and all the complications of that to know that the answer is never, ever, ever tell that to anybody else ever.
Fair. Okay, so are we saying that potentially we limit the scope of what we mean by material witness representation to just the fact of their testimony and leave to potential pre-petition work the underlying case issues that a material witness might reveal?
I think that works.
Okay, cool. Let me put that in the notes. So do we feel like there's much of a need for do we feel like there's any need for there to be a requirement that the person be certified to handle the level of case for which the warrant was issued? If we're limiting the scope of what we consider material witness representation to be consultation about testimony and whether or not they are a material witness or that aspect.
It seems to me it should be greater, it should, the issue for the material witness will almost always have the potential to be greater than what the underlying case is.
Mhm.
So that witness's counsel should probably always be more qualified than whoever the attorneys in the underlying case are.
Okay. Does that make sense to everyone else? Do we have a consensus on that?
Sorry, I don't have like any experience in this area, so I just don't feel like I really.
No, you're fine. We know. Like this is a group that has a wide pool of experience, and not everybody is experienced in everything on that pool. So yeah, you were good.
The only thing that crossed my mind, and I suspect this may be, if this is ever an issue, it's resolved way before the court-appointed counsel comes into play, but would extradition ever be an issue between this court-appointed counsel and this material witness?
That's a great question.
Can you repeat the question? I had somebody knocking at my door.
I was just wondering if ever extradition would be an issue between the person representing this witness and and the witness, or would that necessarily all be resolved before attorney and client or putative client ever come in contact?
I don't think extradition would be the process for subpoenaing and getting out of state witnesses to show up is very different and far more complicated than the process for subpoenaing an in-state witness. But arguably, if somebody comes and files a request for the process is they get the other state to say this person is material, and I'm issuing an order saying I want them to be issued a subpoena. Then that somebody from that other state has to come here and have a lawyer here present those documents to the court and request that the court give an order to show cause to the witness to show cause why they should not be required to go to the other state.
No, I wasn't thinking about certificate of materiality. I was thinking subpoenas issued, witness doesn't show up, material witness warrant goes out, extradition could come into play.
Oh, it would be represented in another state then.
I would assume, that's what I would assume, by the time this witness encountered Oregon counsel, all that would have been resolved. But I don't know. I don't know if a issue with extradition could come up by the time the witness was here. That was just what I was wondering. But I imagine it would be resolved by the time this material witness counsel and this witness ever came into contact with each other.
I think that's right. I think that the only way that it would intersect would be person is arrested in the other state and they're facing extradition, and whoever their lawyer in the other state is reaches out to some lawyers here in the state of Oregon to say, hey, can you help us on this, right? And that would probably be in terms of maybe just negotiating with the district attorney to try and get the person released, but that would be something that I don't even think an appointment would be made on. It would just be conflict check and then just doing somebody a favor.
That would probably go where it should go, to as someone extradition qualified, probably then.
Jordan, is extradition something that the criminal work group is explicitly handling?
No.
All right, let's add that to the list.
I do probably 90% of the extradition cases in Multnomah County, so.
Okay. So, well, then I'll punt it to you. What do you think is extradition something that needs to be handled outside of a criminal qualification scheme, given that extradition most frequently comes up in the scope of, well, I guess not. I mean, it doesn't have to. We always just handle them as part of arraignments, so they were handled as part of the criminal docket.
There's the way that my office does it is I accept all of the appointments on standalone extradition cases. But if somebody is arrested on a local case and they're being held locally and they also have an extradition matter, the lawyer who represents them in the criminal case will also represent them in the extradition matter. So there is a frequent overlap with criminal representation. The qualifications, I think a person can be misdemeanor qualified and handle it so long as they have a good working understanding of the Uniform Criminal Extradition Act, which is in Chapter 133 of the Oregon Code.
Is it something that we would want to split out as an explicit other certification, or if it's any misdemeanor attorney could handle it so long as they know the uniform extradition? Is it a compact or an act?
It's interesting. There's essentially a Uniform Criminal Extradition Act that's been adopted by 48 of the 50 states, and it's not uniform. There's
no, yeah.
high degrees of similarity, but there are some differences.
Yeah. Yeah, I assume it's uniform in the same way that the Uniform Parentage Act is uniform. Okay. So then, okay. Same question though, is that something that could just be folded into the misdemeanor standard?
The other option is to put it in performance standards for people to follow when they're representing people in extradition cases, as opposed to making it a qualification.
It
Yeah,
seems
can
like
you-
that, just from the way you described how people are getting these cases, it seems like that makes more sense if it's the person that's already appointed is handling the extradition as well. You'd want like information about training and performance, but maybe not having to choose the attorney based on that.
I mean, there are certainly going to be areas of law where, sorry, I have a cat who is desperately trying to get outside. I'll be right back. Yeah, it looks like our special door is not currently functioning. That's fun. Okay, so then okay, let's consider that to be part of a performance standard. There are certainly areas of practice, like, do you have to know exactly all of the ins and outs of the traffic code in order to be a misdemeanor attorney? Familiarity, sure. Deep understanding, nah. I think we can probably throw this in with that. Okay, cool.
So one thing, although it's occurred to me, the one thing that I would suggest in terms of that does have an overlap with our job here is that when a governor's warrant has been produced and there is a argument or a challenge to be made to it, that challenge is made via a petition for a writ of habeas corpus. And so extradition attorneys should be qualified in habeas practice. Or Meg came and gave a fantastic presentation on habeas to our office the other day, or have the ability to get it to at least help the client get the habeas filed and then help them find counsel so that they can petition for counsel. In Multnomah County, they just let me represent people on habeas matters because they're my clients already. Right. But that's not always going to be the case for every county.
Well, yeah, no, sure. And there may not be that well-known and immediately available resource in every county for that kind of a thing. But if we simply make it a performance standard that, you know, once the governor's warrant is in, if there's issues, you know, to reach out to habeas counsel, or you're capable of handling habeas yourself, then I think that can be handled as a performance standard rather than necessarily qualifications. Okay. Meg, does that sound right to you? Cool. Okay. Then I think that does it for extradition. We will not have an explicit piece. We'll just make a note that needs to be handled as part of performance standards. Okay. Material witness, sounds like we're going to be wrapping that into making a recommendation on criminal standards for that. Okay, so, excuse me. I guess that wraps those up. I think we didn't ever actually talk about mandamus, but let's set that one aside because that's a longer discussion. I think we were talking about contempt at the beginning of today. Do we reach somewhere, and I just failed to make a note of it, about whether this was going to be oh no, Ed's going to be doing research. That's right. Okay. So let's step back up and let's talk habeas. Meg, I'm remembering correctly that you're our expert there. And Ed, I think if I remember right, you've done some work in habeas too.
Yeah, I've done, close to 100 habeas cases in trial court. Meg has obviously a different perspective.
Yeah, I wonder if it would be, well, just because there aren't any, as far as I could see, um, like examples, standards for habeas cases in the resources that we have. If it would be easier to start with like post-conviction and then kind of
Sure, we can
build
do
from
that.
there. I don't, I mean,
Here,
yeah.
and I think we're gonna have some overlap, but I think with PCR, I think it's really important. It not in every case, but in a lot of cases, it is going to be really important to have a background in criminal defense. Just understanding in PCR. Some cases will be different, but in habeas, I really don't think it matters. You really don't need background in criminal defense. You need to know some evidence and how to litigate, but
Mhm.
that's where the two, I can just think of a lot of PCR cases where a great civil litigator could do a lot with it, but if they don't understand the criminal process, it's gonna have a lot of potential to miss things on, on a serious one. So that's the key thing I would see. But for habeas, if you've got a certain amount of trial litigation experience, be it bench trial, jury trial, understand working rules of evidence, anybody could go in and handle one of those. But again, yeah, with some of the PCRs I've seen, it's like if you took the best civil litigator in the world, there's a lot they could do with it. But if they don't have background in criminal cases, I think that could be problematic.
Do you
Okay.
think that's true for the like authority for confinement habeas cases too? That you also don't really need.
Yeah, I think so. I mean, and I've done medical conditions. I've only done a couple cases that were off the beaten path, but uh but maybe not. I mean, like you said, if you don't know complex sentencing, felony sentencing and that kind of
Yeah.
thing, that I defer to you a little bit on that, Meg, about the difference, because yeah, the authority for confinement, and you don't understand how guideline sentencings and upward departures and stuff work. That may be a problem.
Yeah, I guess that's kind of what I was thinking. It was just like the sentencing issues and then extradition too. Um, and I don't know. It seems like I guess for those, you're not doing as much issue spotting. It's kind of like coming to you with the problem, but um, I don't know. I find the like authority for confinement ones a little bit overwhelming when I get them, just because I don't have that kind of like trial background at all. And I don't have the same kind of familiarity with the sentencing guidelines of working with them all the time. Um, but I don't know if that's something that, yeah, but you might be able to get that just from doing the case with civil background.
Okay, so from our previous, we had talked about authority of confinement having possibly two tiers, the extradition and the other more complicated authority of confinement cases. Is that something that we still think is explicitly two separate tiers? I know we had also talked about authority for confinement being a separate thing from conditions of confinement as a qualification path or set. And if it is, what would we want the extradition level to have, and what would we want the other to have in addition?
I don't know, Joe, do you have thoughts on that since you've done extradition habeas?
Yeah, so the extradition habeas is, for the most part, I mentioned it during the last meeting, it's limited to a very few number of issues that you can actually challenge. It's always an authority of confinement challenge. Those challenges are, I don't remember them off the top of my head, but they're discreetly and well laid out in a United States Supreme Court case called Michigan v. Doran. And so I think that knowledge of the Uniform Criminal Extradition Act is important. And then the thing where I think most criminal attorneys are going to be out on a ledge is the civil procedure of habeas. And I think that's where I would focus and have a baseline about understanding how those civil pleadings work. And habeas is kind of weird anyway, and how it certainly causes a defense attorney's mind to twist around because they have to start referring to their client as the plaintiff, which is something that we very, very rarely do. And so there's even a little bit of a dissonance with it. So I would say understanding of at least the civil procedure associated with habeas. And then to the degree that we are separating out, they don't, I wouldn't say that they would need to have any sort of qualifications for conditions of confinement habeas challenges. That can be something different, and I understand is more complex.
So did I misunderstand then that the more complex is not necessarily authority of confinement, but that's where we're talking about conditions of confinement? Or is there more complex authority of confinement issues that we want to have as a separate thing from extradition authority of confinement?
There's
cases?
Probably more complex about, and that would go into, say, felony sentencing, right? The judge gave you, I don't know if this would even be eligible for a habeas, but say a judge gave you a gun minimum when they weren't allowed to. And then for whatever reason, you've missed your appeal or your ability to do that. You arguably could habeas that, and that would be an authority of confinement habeas.
I think what came up before in terms of degrees of complication also was a concern that some of the condition of confinement can have complex expert witness issues with, medical and psychiatric. And I think that was a concern. You get somebody who just really hasn't done a lot of litigation. And also, as Joe was saying, you're plaintiff now, you have a burden of proof. So it's one thing too, as a criminal defense attorney, to do some expert witness. Now you're having to present complex expert witness testimony and having the burden of proof. So I think that was what was raised in addition to what, Joe said, how you've got some different degrees of complexity, I think.
Yeah, for conditions of confinement, you would also need like investigation skills, right? And like client interviewing. You're reviewing medical records, like working with the experts, all of that kind of thing. And that isn't going to come into play the same way for authority of confinement.
Okay. So is this then a hierarchy potentially of authority for confinement either as one step on its own or split out into extradition as a base level and other authority for confinement issues as a mid-tier, and then conditions of confinement above that? Or
I
are
think
they
they're
like a branching path?
Yes, I think they're branching because I think the skills are just separate.
Okay.
And you don't need to be able to do the like authority for confinement stuff to do conditions of confinement and vice versa. As far as like steps for extradition versus other authority of confinement cases, I think you could do that. I don't know if that's like, I'm curious, kind of like, is that useful? Would that be useful in having, like, knowing that you have a pool of people that are qualified to do extradition habeas, but not other kinds, versus just like, here's our pool of people for authority for confinement cases. They can do extradition and everything else. Are there so many people that we want like those subdivided that way that are going to be in this like pool of people, or is that kind of
So one of the benefits of,
like, I don't know. Yeah.
One of the benefits of doing it separated like that could be if having extradition habeas as an entry level practice to get people in the door and available for potentially mentorship opportunities to develop their practice further. we may not have a huge number of people doing these kinds of things right now. But if we have that lower level certification level, people may be more willing to dip their toe in and say, hey, I actually do meet the qualifications to handle this. So I want to try a couple. And once they're in the community, be able to develop that practice further. And that builds a stronger bar. I mean, that would be kind of my thought on that. It's also entirely possible we want to just say, all right, habeas has 2 categories now, authority and conditions, and you can be certified in either of them. We would want to be careful of if there's some incredibly complex. This is to give you a little frame of reference. This is one of the issues that we're having to deal with pretty heavily in the dependency work group. Is dependency is at base level extremely complicated. Like the life of a dependency case and the fact that every case can result in termination of parental rights. You're walking in day one knowing that there's a potential death sentence at the end, and you don't know whether your client's going to be able to avoid it. So we have a difficulty in, okay, so what is the way we get people in the door to this practice? So that's kind of one of the thoughts here is if we have a lower level, you can certify for this really easily. We can start getting would it be, and Joe, maybe you're the best person to ask this one. Is it possible for somebody to walk out of law school and start handling extradition habeas cases? I mean, with a little bit of training and a little bit of support, would it be possible for somebody to do that? And then we've got an entry level and something that they can work towards.
I think so.
So how about this as a structure? What if we have extradition level habeas as an entry point, and from there you branch into more complicated authority of confinement and otherwise conditions of confinement cases? Would that work?
The only issue I see about that in terms of the branching the extradition into the conditions of confinement is my recommendation that for somebody to do a extradition habeas should have knowledge of the Uniform Criminal Extradition Act. I don't necessarily think a conditions of confinement habeas attorney needs to have knowledge of the Uniform Criminal Extradition Act.
Yeah, I think like the baseline for everybody is going to be like civil rules of procedure and like the habeas statutes, right? And like basic sort of litigation and evidence, like basic litigation skills. And then, right, for extradition, it's going to be understanding the act. And then other authority of confinement is going to get into sentencing for sure. And I'm not sure if there are other, trying to think of like what else I've seen there. I guess, yeah, I feel like extradition and sentencing are the two. I don't really know what else.
So the current habeas standards that we have are just lesser felony criminal certification. That's it. If you've got lesser felony, is that level, Joe, what I'm hearing from you is that to do extradition, that level of experience is not necessary.
Correct, with the exception of learning the habeas procedure. The first, I taught myself habeas stuff, and it took me forever to figure it out just by sort of going through and reading the statutes.
Yeah. Right.
And I'm murder qualified.
Right. Well, and that's kind of where I'm like, do you think that the level of litigation experience needed in order to handle extradition habeas is at a lesser felony level? Or is it, all right, we can get people in the door with this, they don't need to have as much litigation experience, and then say for the other authority of confinement, yes, you need to be at least or you need to have an experience, a level of experience equivalent to what someone at lesser or what we're going to call it in the future, felony, or Measure 11. I don't know that we need to go that high, but I'm throwing out like potential options. So, for instance, under here, experience with sentencing guidelines and certified for either criminal or juvenile felony cases, as a rough idea of how much litigation experience someone would need.
I think the litigation experience that somebody needs is pretty low. You don't have a jury trial with a habeas. In terms of the issues, it depends on how, I mean, you may be having somebody that's received a very complex sentence from a major felony case. So certainly I think that you would need to understand felony sentencing, whether you are major felony qualified or not. But to go back to your initial question, I do think that habeas fugitive stuff is a get them in the door kind of thing. Just those understandings of the process and the Uniform Criminal Extradition Act can get you there. Coming out of law school, yes, and then branching out, I leave it up to the group to determine sort of how exactly to say somebody what qualifications. I would say understanding of, to the degree that we're thinking that's kind of it, sentencing issues is the known universe of authority of confinement challenges, and you got to know felony sentencing.
Meg?
I think that makes sense.
Okay. So we can take out this certification for felonies and just we can define, and I would recommend that over until we next meet, maybe one of the things to try and nail down is how do we quantify the experience with the felony sentencing guidelines into a way that makes sense as a qualification standard. Does that make sense for next step on that piece?
Yeah.
Okay, cool. And then, so for conditions of oh, sorry, Ed, were you saying something?
Yeah, and I know you said what we'd address, but I wonder if it's some baseline of, a Measure 11 sentencing or, experience with Measure 11 sentencing, then that'd mean probably stepped up, but
Okay.
I mean, I guess Measure 11 sentencing is really easy. It's just a number. There's all these other rules like the 200% rule, the 400% rule, the shift to I rule. That nobody knows until they go and research it again every time they have to come up to it.
yeah, and I guess so Measure 11 sentencing, I guess it would be some sort of serious crime sentencing, but yeah, good, that's great.
Yeah.
Point. Thank you.
It seems like kind of what I was saying. The litigation experience probably doesn't need to be very high. It's more like you do need to be familiar with the felony sentencing, but not necessarily I think you could get there just by researching and studying it rather than needing to have the experience of actually going through a trial and going through a felony sentencing. I don't know that necessarily is what the experience is required. It's more the knowledge.
So is it fair to say that that the authorities for confinement is more motions and briefing oriented than it is trial room, courtroom work?
Yeah.
Okay.
There's a hearing, but it's not an extensive trial or anything.
Does it just because I'm very unfamiliar with this, is there much of an evidentiary record created outside of or are there many factual disputes for authority of confinement?
There can be.
Okay.
But not huge, not the way conditions of confinement, and not even as much as PCR, I would say.
Okay.
In my experience, yeah.
Okay.
I will talk to my coworkers too, who've probably handled more, or collectively we've handled more of these, so can kind of brainstorm some other things that might come up.
That sounds great. I would appreciate that. Thank you. Okay. Then let's shift over to and double check. Do we have the right list of things for conditions of confinement? Experience with medical and psychological records and expert testimony, investigation, and client interviewing as kind of the key skills that separate that out.
I think this also would be sort of like the civil commitment piece of working with clients, at least some of the time, that have intellectual and developmental disabilities.
So something akin to a diminished capacity.
Yeah, I mean, certainly not all the time. There are plenty that are just about like physical impairments and that kind of thing. But
is that something that we necessarily want to call out as an explicit qualification, or could that be something that we handle as a performance standard?
yeah, like training or performance, that probably would work.
Okay. Okay. If we were to want to quantify what this experience looks like, what does the group feel that would look like? I recognize that is not an easy question.
You're specifically experienced in terms of conditions of confinement.
Mm-hmm.
You know, investigation, my understanding of what we're referring to there, I those basics came from having a misdemeanor criminal defense practice. You know, what do I need to know to present the case in court? The medical psych records issue, I don't, you know, for me, by the time I was doing serious felony criminal defense, I had a lot of expert witness work in court. You know, but I don't know how that comes about. You know, doing driving under the influence cases, we get all kinds of different expert issues, and I'd have, you know, mental and intoxication defenses, but I don't know where that comes from otherwise, you know. But it's definitely, I don't think you can replace that experience of being in court dealing with expert witnesses, you dealing with you know, trials where that have expert testimony.
So what about
Yeah.
something like where we how do I frame this? So like for instance in the current civil commitment standards, we require somebody to have had I think it's like 2 cases in which the use of psychological experts and consultation with the client on psychological or psychiatric reports occurred. Do we want to make something explicit like that? Or do we want to say, all right, if you've got felony or something, some other ways to satisfy that, like there's a lot of expert witness usage in dependency cases. Maybe we
Yeah,
want to say
we
if
have
you're
some,
sorry, go ahead.
we have some habeas attorneys now that have started in the last few years that have a medical malpractice background.
Mhm.
And that seems to be like very effective just because they're really familiar with the standards of what doctors should be doing and how to like argue that kind of claim, how to work with medical experts, medical records, all of that. So I think framing it not just in the like, I don't think we want to just pull from like criminal defense attorneys for these
Right.
cases. I think making this a lot broader than that is good and helpful. And I mean, we can get more people and qualified ones. So I think, yeah, like the civil commitment, maybe where it's if you've had a trial where you've used whatever medical records or an expert and not tying it to the criminal kind of case would be better than trying to like keep it with a tier in the criminal standards.
Yeah, you could potentially make it witness examination, deposition, or trial examination of a type of witnesses, and then you wouldn't exclude those people because if they're deposing MDs and stuff, they know what they're doing. But yeah, I think that would be a substitute, either number of depositions or number of witness examinations, cross or direct, of experts in trial.
Okay.
Yeah, yeah, I like that.
Okay. Okay.
Kevin, if I could ask a question real quick.
Yeah, go ahead.
Having done relatively little work in depositions in my career, would it be equivalent to examine someone in a deposition and a trial as far as experience goes? Are those, either or would you have had to do more work in depositions and less work in trials to qualify or something like that?
I think just having experience in both, I think that for these purposes, you could make them equivalent. There are a lot of differences, but if someone is getting the certain number of depositions of medical doctors, of psychiatrists, they will have spent the time learning and preparing, versus whether you're presenting a defense expert witness or cross-examining an expert witness, they're not going to be equivalent. But I think you can find a fair number that represents both.
Joe.
On the note of deposition versus trial stuff, I will note that people who, like myself, who have spent their entire career as a criminal defense attorney, I've never once done a deposition. We don't have those in Oregon. So, but my wife does depositions. She's a former criminal defense attorney. In terms of, it doesn't seem, from talking with her about it, it doesn't seem like it's much different.
Okay. So we could put that in as a number of cases hearings. I'm going to word that better.
Yeah,
at some point.
It does seem like since they will have to, there will be a hearing. So it seems like a little bit of experience with an actual hearing of some kind, either a trial or other kind of contested hearing would probably be useful.
Okay,
I don't know. Just that would
litigation experience.
Yeah.
As a separate. Okay, so maybe that's the thing that we can have people satisfy by, like, if you're felony qualified or your dependency qualified, or civil commitment qualified or something like that, odds are you have the litigation experience that we would be looking for.
Right.
So we've got some amount of you got to hit somewhere in here. Do we need it to be? I don't think we do, but I'm happy to hear other opinions on this. Do we need it to be explicitly public defense litigation experience?
I don't think so.
Okay. I can't see the first page, but didn't we have a litigation experience for all habeas?
Yes.
Litigation and evidence experience. Under number 2. So I don't know that it needs. I 100% agree. Unless you've actually done it, you can read the evidence code all day long, but until you've actually done litigation, until you've experienced it, it's not going to be the same. But I don't know if there's a distinction of the litigation experience and evidence experience between the two types.
Yeah, I agree. I don't think there is. I forgot about that.
Okay. I will say that was, I put those up there before we kind of conceptualized the extradition habeas work as a get them in the door opportunity. So that may take some retooling, but I'll figure out how we want to. It may just be, let's put litigation experience in with the higher level authority of confinement stuff, and also with the conditions of confinement, and we'll just separate it out that way or something along those lines. But okay, cool. All right. Okay, I do just want, because we're at 1:03. I want to do a quick time check, see how everybody's doing, and make sure that we are, if folk need to go, we can do that.
I
So-
gotta go. I got a hearing at 1:30.
Okay, that's fair. I think we've hit a good
Good luck.
spot
Thank
here
you.
today. And I think
Happy
we've got
Thanksgiving.
I think we've got some good particulars for what we're looking at for next our next meeting. So I'm good. I think I'm good with, we can end here today, and then we can come back, and I'll send out a follow-up email later today with the notes, the stuff that we've worked on, and what I think our next steps are. Does that sound good? Awesome.
Sounds
All
great.
right. Thank
Happy
you, everybody.
Thanksgiving, everybody.
Happy Thanksgiving.
Happy
Very
Thanksgiving,
much
everybody.
appreciate everyone's work. Bye.